as suppressors illegal nationwide, just as they are in New Jersey.
This administration issued a ban on bump stocks, a ruling that ever since has been challenged by gun right advocates.
To propose regulations to ban all devices that turn legal weapons into machine guns.
Those are accessories to semi-automatic rifles that increase the rate of fire.
The State House still has to vote on the bill. 9 on your side's Craig Smith looked into how much difference a suppressor makes.
Since the 2017 mass shooting at that music festival in Las Vegas.
Supreme Court will consider a challenge to a Trump-era ban on so-called bump stocks.
A new law for suppressors got passed and approved. It's being used alongside efforts to change the rules for suppressors in the National Firearms Act and Arms Transfer and Security Assistance. There's also a lawsuit in Texas pushing for more freedom with suppressors. A new era for suppressor ownership. In a bold stride towards reshaping the landscape of firearm regulation, the American Suppressor Association has erupted with excitement as Rep. Jeff Duncan and Rep. John Carter reintroduced the Hearing Protection Act. This legislative juggernaut, once championed by Rep. Matt Salmon in the 114th Congress, seeks to emancipate suppressors from the shackles of the antiquated National Firearms Act, ushering in a new era marked by a swifter, more efficient process. Knox Williams, the dynamic president and executive director of the ASA, exudes enthusiasm as he heralds this significant move. The American Suppressor Association believes that citizens should not be burdened with a tax to safeguard their hearing while exercising their Second Amendment rights, he emphatically declares. Williams recognizes that the introduction of the bill is merely the inaugural drumroll of a transformative process aimed at reforming federal law. At the heart of the HPA is a provision that promises to right a past wrong, a pledge to refund the $200 transfer tax to applicants who dared to invest in a suppressor after October 22, 2015, the symbolic inception of the legislation. This financial olive branch underscores the commitment to rectifying a cumbersome system that has hindered law-abiding citizens from exercising their rights without breaking the bank. Popularly known as silencers, suppressors emerge as the 21st century sportsman's silent ally in preserving their precious sense of hearing. Dispelling Hollywood myths, these accessories don't render gunfire silent. Instead, they function as sophisticated mufflers, capturing expanding gases at the muzzle and orchestrating a controlled cooldown. The result? A reduction in gunshot noise by a considerable 20 to 35 decibels, akin to the protective embrace of earplugs or earmuffs. Beyond individual hearing preservation, suppressors address the perennial noise concerns of communities residing near shooting ranges and hunting grounds. Yet the journey of suppressors in the U.S. has been fraught with federal regulation since the passage of the National Firearms Act in the distant echoes of 1934. This legislative relic governs the transfer and possession of specific firearms and accessories, including suppressors. The current labyrinthine process for potential buyers involves navigating a convoluted Form 4 application, shelling out a hefty $200 transfer tax per suppressor, undergoing a background check reminiscent of purchasing a firearm, and enduring the tortuous wait for ATF approval. A stark contrast to the European landscape where many countries impose no regulations on the purchase, possession, or use of suppressors. As the HPA makes its triumphant return to the legislative stage, it carries the hopes and aspirations of sportsmen, enthusiasts, and advocates who have long yearned for a more rational and accessible approach to suppressors.
Gun enthusiasts hope lawmakers will pull the trigger and lift the ban on silencers.
As suppressors illegal nationwide, just as they are in New Jersey.
The State House still has to vote on the bill. 9 on your side's Craig Smith looked into how much difference a suppressor makes.
That the Republican-led Senate would finally hold a vote on gun safety legislation.
The bill's reintroduction sparks a flame of optimism, symbolizing not just a fight for auditory well-being, but a battle against the bureaucratic red tape that has entangled the rights of law-abiding citizens for far too long. With Representatives Duncan and Carter at the helm, the ASA stands ready for the marathon of reform, knowing that the journey has just begun, but the destination holds the promise of a more liberated and sensible future. Court reverses Trump-era bump stock ban. A federal appeals court in New Orleans has made a groundbreaking decision to reverse the Trump administration's ban on bump stocks. These controversial devices, infamous for enabling rapid firing from semi-automatic weapons with a single trigger pull, has been thrust into the spotlight as a response to the tragic 2017 mass shooting in Las Vegas. The ban, a measure aiming to curb potential misuse of such accessories, has been a battleground for gun rights activists challenging its legality. Now, with a resounding 13-3 vote, the Fifth U.S. Circuit Court of Appeals has made its mark, sending shockwaves through the legal landscape.
Firing rapidly, almost at the same rate as a machine gun, and that's why these will be banned starting tonight.
This administration issued a ban on bump stocks, a ruling that ever since has been challenged by gun right advocates.
Las Vegas was terrible, but to do a knee-jerk reaction.
Since the 2017 mass shooting at that music festival in Las Vegas.
Crucially, this legal skirmish focuses on the nuanced interpretation of federal legislation rather than the broader canvas of the Second Amendment. The argument pivots on whether bump stocks can be classified as illegal machine guns under federal law. While opponents contend that these accessories fall outside that scope, the ATF has consistently held an opposing view, a stance currently backed by the Biden administration. Judge Jennifer Walker Elrod, leading the charge in the majority opinion, brought clarity to the matter by asserting that a bump stock does not align with the technical definition of a machine gun as articulated in the Arms Control Act and the National Firearms Act. This determination emerged from a meticulous examination of semi-automatic firearm mechanics and a straightforward interpretation of statutory language. The court's ruling declares that bump stocks, designed to harness recoil energy and facilitate rapid firing, do not fall within the statutory definition of a machine gun, outlined in two distinct federal statutes. Despite challenges from other circuit courts, the Fifth Circuit's decision to revisit the matter prevailed after hearings on September 13. At the heart of this debate is the functionality of bump stocks, which leverage recoil energy from semi-automatic firearms to achieve rapid firing without necessitating manual trigger resets. The majority stance in the court was that the operation of a bump stock, involving repeated trigger pulls, does not align with the legal definition of a machine gun. However, not everyone in the judicial arena is on the same page. Judge Stephen Higginson, in a dissenting opinion, adamantly disagreed with the majority, asserting that bump stocks unequivocally qualify as machine guns under federal law. He criticized the majority's lenity concept, expressing concerns that it might lead to default victories for defendants when legislation doesn't explicitly criminalize certain behaviors. The decision garnered satisfaction from gun rights advocate Richard Samp, who testified against the ban on behalf of a Texas gun owner. The Justice Department, on the other hand, maintained a conspicuous silence in the aftermath, declining to respond to inquiries during the evening. A notable facet of this legal drama is the political composition of the appeals court judges. With all members, except one, appointed by the Republican Party, the decision stands as a pivotal moment in the ongoing legal discourse surrounding bump stocks and their classification under federal law. As the case now returns to a lower court for further proceedings, the ripple effects of this ruling are poised to shape the contours of future firearm regulations and Second Amendment debates. Bump stock battle. In the riveting legal saga known as the Cargill v. Garland case, the Fifth Circuit Court of Appeals emerged as a beacon of justice, overturning the ATF's controversial bump stock regulation. The legal battle centered on whether the ATF's final rule should bow to Chevron or yield to an independent rule known as the Lindy Rule. Picture the courtroom drama: a decisive 13-3 vote by the Fifth Circuit's Amang panel, declaring that the ATF had overstepped its bounds by categorizing bump stocks as mash guns under the General Motors Act. The court, wielding the sword of individual liberty, deemed the ATF's regulation a breach of legal tolerance. In response to this legal upheaval, the ATF hurriedly filed a petition with the Supreme Court, seeking a review of the Fifth Circuit's decision. They argued that the decision clashed with rulings from other circuit courts, igniting a legal maelstrom. The ATF contended that evolving circumstances had further complicated the legal terrain, creating a pressing need for the Supreme Court's intervention. Enter the Hardin decision, a recent ruling by the Sixth Circuit Court of Appeals that added fuel to the fire of bump stock regulations. With circuit courts diverging on whether to allow the purchase or possession of bump stocks, the ATF argued that the Supreme Court needed to reevaluate the entire landscape.
To propose regulations to ban all devices that turn illegal weapons into machine guns.
Supreme Court will consider a challenge to a Trump-era ban on so-called bump stocks.
The Supreme Court has rejected an effort from gun rights advocates to challenge the ban on what are called bump stocks.
Those are accessories to semi-automatic rifles that increase the rate of fire.
The ATF's concern went beyond legal consistency. They believed bump stocks posed a substantial risk to law enforcement and the public, a claim made without compelling evidence, according to critics. As the legal battle raged on, both sides implored the Supreme Court to revisit the case. The ATF, fearing a patchwork of conflicting regulations, emphasized the urgent need for a unified legal framework. The Sixth Circuit's decision, which found the Act's wording ambiguous, raised the stakes, pushing the ATF to argue for a standard more aligned with the rule of lenity than the Chevron deference approach. The Supreme Court found itself at the epicenter of this legal storm, a position it often assumes to resolve conflicts of law and provide guidance on pivotal legal matters. The Fifth Circuit's decision had far-reaching implications, potentially setting a precedent that would thwart the ATF's enforcement efforts in the region. With conflicting opinions and decisions from other circuits, the Supreme Court faced a formidable challenge in deciding whether to grant review. In this high-stakes legal drama, both parties approached the Supreme Court, but their strategies diverged. The ATF resisted the inclusion of the rule of lenity in the case, asserting that their initially submitted question adequately addressed the issue. The nuanced dance between the two parties underscored the complexity of the impending legal dispute. The Supreme Court's interest in the case heightened due to the potential for notable differences in federal law and ATF enforcement. The specter of conflicting regulations loomed large, compelling the Supreme Court to seriously consider taking up the case. As the legal pendulum swung, the fate of bump stock regulations hung in the balance. In conclusion, the Cargill View Garland case's journey through the legal labyrinth showcased a clash between regulatory power and individual liberties. The Fifth Circuit's resolute stance against the ATF's overreach set the stage for a Supreme Court showdown, with the rule of lenity and Chevron deference as the protagonists in this legal saga. The outcome, yet to unfold, promises to leave an indelible mark on bump stock legislation, shaping the contours of ATF authority and the interpretation of firearm regulations in the U.S. Silencing the controversy. In a legal tussle that echoes through the chambers of firearm regulation, the Texas Suppressor Freedom litigation sought to dismantle the NFA and ATF prohibitions on suppressors manufactured within the Lone Star State. The case, previously known as Paxton v. Dettelbox, unfolded with the suspense of cross motions for summary judgment, leading to a pivotal decision that seemed to throw a legal curveball. The judge's ruling, akin to a softball pitch, hinged on the invocation of standing, deftly sidestepping the thorny discussions at the heart of the matter. The court, with an air of finality, deemed that the plaintiffs lacked a tangible injury to meet the standing requirement, a decision that rippled through the intricacies of constitutional interpretation. At the epicenter of this legal drama was Texas House Bill 957, a legislative gambit aimed at exempting all suppressors manufactured and stored within Texas from federal regulation. The argument rested on the premise that since these products existed solely within the boundaries of Texas, they fell outside the realm of interstate commerce and, by extension, were exempt from ATF regulation. Texas, backed by individual plaintiffs, launched a legal offensive against the federal government, triggering a showdown in a federal court with cross motions for summary judgment. As arguments reverberated through the courtroom, the judge faced a trilemma: allow the plaintiff's motion, rule in favor of Texas and the individuals, or accede to the government's request for summary judgment in favor of the ATF. The court, donning the robes of authority, ultimately decreed that the government had the right to emerge victorious, pointing to the plaintiff's alleged lack of legal standing. The judge, in an eloquent legal dance, elucidated that grievances against legislation or government actions alone did not serve as grounds for a lawsuit.
Biggest benefit is that they can now protect themselves against their biggest, most substantial threat, which is external crime.
Is the goal of the ATF to go after and criminalize law-abiding Americans? Is that what you're asking for?
No, there were specific products that get presented for classification.
This legislation strip Americans of their rights, but it would do nothing to make our community safer. We know that because Democrats tried it before.
This current law requires all silencers to be registered.
The Constitution, in its wisdom, granted federal courts the jurisdiction to settle genuine conflicts. The plaintiffs, the judge argued, needed to demonstrate ownership of an illegal silencer or engagement in prohibited behavior declared unlawful by the ATF to establish standing. Alternatively, they could bolster their case by proving direct threats from the ATF concerning the manufacture of homemade suppressors. To successfully challenge a criminal statute before its implementation, a party had to establish a reasonable danger of sustaining direct injury from the law's execution. The judge, however, introduced a legal paradox. A plaintiff would have to engage in actions deemed unlawful before legally challenging the ATF, akin to falling on their own sword for the greater cause of the Second Amendment movement. In a decisive turn, the judge rejected the notion that merely claiming the statute infringed upon rights and violated the Second Amendment sufficed to establish standing. The plaintiffs, the judge argued, must subject themselves to the exact process they sought to scrutinize. The judge dissected Texas's standing to file the complaint, determining that the state could not champion its citizens against the federal government regarding the application of the NFA to suppressors manufactured within Texas. The state, the judge asserted, could not act as a volunteer litigator representing its citizens' private interests. In a legal denouement, the court granted the government's request for summary judgment, dismissing the lawsuit in favor of the ATF. Yet the legal saga left a door ajar for potential resurgence. Texas, armed with a willingness from plaintiffs to disclose their identities, could refile the case. The courtroom drama, though seemingly concluded, hinted at the possibility of a sequel, one where the identities of the players might change, but the legal stakes remained as high as ever. Southern States Suppressor Standoff. In the sultry heart of the American South, where whispers of change often echo through the cypress trees, a subtle yet profound shift in the legal landscape has taken root. Mississippi, influenced by the winds of controversy swirling around the Texas suppressor freedom lawsuit, has unfurled its own standard-bearer of defiance in the form of House Bill 912. Texas, ever the bastion of individual liberties, set the stage with House Bill 957 in 2021, a legislative gambit aimed at exempting suppressors crafted and confined within its borders from the iron grip of federal regulation. The heart of the Lone Star echoed with the rumble of discontent, as Texans, including a few aggrieved souls, took their cases to the courts, suing the ATF in a case now known as Paxton versus D. The courtroom drama unfolded in the Northern District of Texas Federal District Court, a stage set for a clash between the indomitable spirit of Texas and the bureaucratic might of the federal government. The plaintiffs, it was decreed, had not suffered a tangible injury in the eyes of the law, their grievances deemed insubstantial and thus lacking standing. With this ruling, the government emerged victorious, but the seeds of dissent had been sown. Enter Mississippi, a state with a storied past, now stepping onto the stage as a co-conspirator in the battle against federal suppressor regulations. House Bill 912, a legislative phoenix rising from the embers of Texas's struggle, found its way to the governor's desk and bore the indelible signature of defiance. But this was not a reckless charge into the unknown. Rather, it was a calculated maneuver, intricately entwined with the fate of its Texan counterpart.
Not even the United States military relies on silencers to protect our soldiers' hearing.
I strongly believe the government should protect rather than restrict our rights under the Second Amendment.
When attached to a firearm does not convert the weapon and would not alter its classification.
Back in 2010, there were just over 285,000 registered silencers.
The echoes of Mississippi's intent reverberated through the legal corridors, catching the attention of keen observers who glimpsed its presence in the Texas suppressor freedom case. In an intricate dance of legal choreography, Mississippi sought not only to free its suppressors from the clutches of federal oversight, but also to tether its fate to the outcome of the Texan saga. Its efficacy, it declared with legal solemnity, would remain dormant, latent, until the resolution of the Texas lawsuit, the very epicenter of the suppressor struggle. Like a legal pendulum, Mississippi's fate swung in tandem with the outcome of Paxton versus D, linking arms with Texas in a synchronized dance of legal rebellion. The core tenet of House Bill 912 mirrored the Texan triumph, aiming to create a haven for suppressors exclusively birthed and cradled within its borders. The law boldly declared that suppressors born on Mississippi soil would be immune to the sweeping arms of federal laws and regulations, rendering them sovereign entities in the eyes of the state. Yet House Bill 912 didn't stop at mere defiance. It brandished a financial cudgel, a provision that struck at the very heart of compliance. Any government agency within the Magnolia State that dared to aid in the enforcement of federal suppressor laws would find itself starved of state funding. As the legal saga unfolded, the eyes of the nation turned to the Lone Star State, where Paxton versus D continued its journey through the labyrinthine corridors of the legal system. The Texan plaintiffs, their resolve undeterred by a district court setback, now pin their hopes on the higher echelons of the legal hierarchy. House Bill 912 wasn't just a law, it was a chapter in a broader narrative of states asserting their rights, challenging the overreach of federal authority, and carving out spaces where the spirit of individual freedom could flourish. The echoes of House Bill 912 and the Texas Suppressor Freedom lawsuit reverberated through the legal annals, leaving an indelible mark on the evolving tapestry of American constitutional discourse. Texas challenges ATF on suppressor regulations. In a recent legal saga unfolding in Texas, a federal judge made a crucial determination in a case challenging the government's regulation of unregistered silencers. The judge acknowledged the plaintiff's concern over the government's track record of prosecuting illegal possession of such devices, but asserted that the individual complainants failed to provide concrete evidence of owning illegal silencers or engaging in prohibited activities. The judge underscored the importance of a credible threat of prosecution, pointing out that the plaintiffs did not demonstrate such a threat and emphasized that criminal law doctrines prevent convictions based solely on thoughts or intentions. Consequently, the judge deemed the fear of prosecution among individual plaintiffs as speculative, lacking the substantial basis required for Article III standing.
The NRA wants you to believe that silencers are necessary to protect the hearing of gun owners.
In 2012, the Obama-era ATF recognized that these devices serve a legitimate function.
And it hasn't been adopted yet. I don't know that it will because it's got riders in it that are inappropriate and should not be included.
Essentially, the judge laid out a clear criterion for standing in Texas. Individual plaintiffs would need to allege actual possession of an illegal silencer or engagement in activities deemed illegal by the ATF. Intent alone would not suffice. Tangible evidence of illicit conduct was deemed necessary for standing to sue the ATF. The court suggested alternative avenues for establishing standing, such as demonstrating direct threats from the ATF or attempting to register one of the Texas-made suppressors with the agency. In a move that reverberated beyond Texas borders, a similar case in Mississippi relied on the Texas precedent. However, in the Mississippi case, the lower court judge ruled that the state itself lacked standing to sue the ATF, contending that the state couldn't adequately represent its citizens in such a legal battle. Consequently, the judge granted the government's motion for summary judgment, swiftly dismissing the case. Undeterred, Texas has taken the legal battle to a higher level, appealing the ruling and urging the Fifth Circuit Court of Appeals to reevaluate the lower court's decision on standing. Texas argued that the case's constitutional significance warranted oral arguments, raising critical questions about the rights of Texans to challenge statutory requirements before complying with them and whether the state can swiftly defend its quasi-sovereign interests in the health and safety of its citizens. A catalyst for Second Amendment changes. The Texas Suppressor Freedom case, currently before the First Circuit Court of Appeals, extends far beyond Texas, influencing states under the First Circuit's jurisdiction. Mississippi is actively using the Texas law as a model for state-level suppressor deregulation, awaiting a Supreme Court ruling on Texas House Bill 957. Mississippi's HB 912 links its enforcement to the outcome of the Texas case, Paxton versus D, highlighting the case's potential for state-by-state impact. Despite these developments, the ATF still regulates suppressors under the National Firearms Act and the Gun Control Act.
The Act would prohibit the sale, transfer, production, and possession of gun silencers.
It's subject to reasonable restriction by government.
Mississippi residents must comply with existing regulation until the Paxton case concludes. The hope is that a favorable ruling from the Fifth Circuit could lead to Supreme Court review, shaping the legal landscape for Second Amendment cases nationwide. That's all for this video, folks. We'll see you next time.